Good evening, everybody. Welcome to today's webinar on the topic of Can Your Dental Office Lease Prevent a Practice Sale? My name is Sina. I'm a senior consultant with Cirrus Consulting Group Healthcare Real Estate Leasing Practice. Delighted to be joining you and delivering this webinar on a very important topic, which is for those of you who are looking to sell your practice, whether or not your office lease agreement can prevent a practice sale. Before I dive into my presentation, a couple of housekeeping items. If you're just joining us, you will have an opportunity towards the end of the webinar to ask questions through the Q&A chat window, which is going to be located on the bottom right-hand corner of your screen. Given the number of attendees we have on today's webinar, the large number of attendees, we're not going to be taking questions throughout the presentation. We'll leave your questions for the end, and hopefully we'll be able to get to most of them today. And for anybody who needs to have their questions addressed after today, should anything come up, as you're thinking about this important topic of negotiating a dental office lease agreement, my contact information is on the screen, so don't hesitate to reach out to me. So some background with regards to who we are. I think it's important for anybody who is attending this webinar to have an understanding of why we're putting on this webinar. Why is it we're discussing the topic of negotiating an office lease agreement and how an office lease agreement can prevent a practice sale. We were founded as an organization by dentists, for dentists back in 1994. As a company, we analyze over 1,000 dental office lease agreements per year, and we negotiate over 500 of the leases that we review annually and track the critical dates for all of them. So not all the lease agreements that we review every single day are actually negotiable, and I'll get to momentarily why that is and what's the timing with regards to negotiating a lease agreement if you're thinking about negotiating your lease. We have negotiated over 10,000 dental office leases since our inception. And today we deliver over 150 continuing education seminars annually across the country, specifically for dentists. And many of you have probably heard about us through whether it's a dental meeting, a local study club, or perhaps you heard us speak at the Yankee Dental Conference or the Pacific Dental Conference for those of you that are joining us from Canada. We work with dentists nationwide and also North American-wide. We have plenty of clients both north and south of the border. Our reach in terms of the U.S. Real estate market is quite broad. You may recognize some of the names on the screen before you. These are a combination of doctors that were looking at starting a practice from scratch, those dentists looking to negotiate a lease agreement for the first time with their landlord, dentists looking to expand their office in an existing lease agreement, seeking to renew their lease and prevent a rent increase, doctors that were looking to sell their practice and wanted to make sure that the lease agreement would not become an inhibitor when it came time to selling their dental office. Our reach in Canada in terms of doctors we've worked with from coast to coast, again, a combination of doctors, and many of you may recognize some of these names if you are located in Canada, dentists that are looking to sell their practice, looking to relocate, expand their office, associates looking to build their practice for the first time or buy their first practice, whether they're general dentists or specialists. We have worked with all of them. And one of the benefits that we have from being able to work with a lot of the colleagues you have today is the notion that we have come across different types of scenarios, and we've worked with clients in quite challenging situations. The purpose of today's webinar is how the lease agreement can either inhibit or facilitate your ability to sell the practice. The key terms within the dental office lease. There are a lot of organizations that claim to know how to negotiate a lease agreement, and when you attend their lectures or seminars, they don't really actually tell you what is in your lease agreement. And we're big believers in educating everybody about the terms in their dental office lease so you can walk away much more informed with regards to how to negotiate that lease with a landlord. Practical advice. We're going to give you some practical advice as it relates to negotiating lease agreements ahead of a practice sale for those of you looking to transition. So with that being said, I want to ask you a question. What is a lease agreement? When you think about a lease agreement, what comes to mind? When I ask this question of countless doctors across both Canada as well as the United States, generally I find most doctors believe it's the amount of rent that you pay, and it's absolutely right. A lease agreement does define how much rent you pay to your landlord. Many doctors believe it's a legal contract, and it absolutely is. A lease agreement is a legal contract that's a binding contract between you and your landlord, and there's terms and conditions that go along with that. Now, what I found is that most doctors, when they're thinking about their office lease agreement, they tend to think about one thing, and that one thing is rent. And the way I like to describe a lease agreement is that, like a lease agreement, and like the check you sign when you buy anything, a lease agreement defines how much money you pay, to whom you pay, and when you make that payment. Now, the difference between a check and a lease agreement is that, unlike a check, your lease agreement, aside from stipulating how much you pay and to whom, your lease agreement comes with dozens upon dozens of legally binding provisions that may significantly increase your liability and potentially prevent a practice sale from happening. And why is this document so important? Well, first and foremost, for those of you that have been practicing in your location for several years, you'll understand the benefit of having a lease if you have a lease agreement, because it provides you with long-term stability and security. When you wake up in the morning and you go to your dental office, what's allowing you to practice out of the location is the notion that you've agreed to pay your landlord a certain amount of rent every month. If you're late paying that rent, or if you were to default under your lease agreement, well, guess what? You no longer have the benefit of being able to practice in the location because the landlord will likely want to evict you. A lease agreement also provides you, if it's properly structured, with minimal risk and exposure. Now, when you look at your lease agreement, have you signed your lease agreement in your personal name? Or have you signed the lease agreement under the name of your corporation? How is your lease agreement minimizing your risk and exposure? Your lease is also important because if it's properly drafted, it should maximize your flexibility to be able to either add associates, expand the office, or perhaps take on a specialist, perhaps sell your office when you're ready to retire. The lease should also provide you with fair and affordable financial terms. When you sign a lease agreement, there are different types of lease agreements. There are lease agreements that you may sign where you're paying your landlord a lump sum amount of rent every month. That's called a gross lease. Or you may be on a lease agreement, which is more common, whereby you're paying the landlord a base rent plus additional rent for utilities, for common area maintenance, and for property taxes. And depending on the type of lease agreement you have, you're going to find that some lease agreements are more in favor of the landlord with regards to how the landlord can pass through any expenses that arise. That's typically the case with a triple net lease agreement, where the landlord essentially passes through all the expenses that come up, including replacing the roof, including, for example, the landscaping, or, for example, if there's a patient that drives through the window of your office, an elderly patient. It happened to a client of mine recently where they, instead of hitting reverse, actually drove straight through in the office, and there was some damage done, and the landlord and the doctor got into an argument as to who would be responsible and whose insurance are going to file the claim under. Your lease should also enhance your ability to eventually sell your practice. And for those of you that are attending today's program, the number one reason you're likely joining us is because you're thinking about selling your office. And we're going to discuss how this lease agreement will help you, if it's properly negotiated, eventually sell your practice. Now, when you're talking about a sale of a practice, what comes to mind? Generally speaking, if you're a general dentist and you're looking to sell your practice, there's really three components to the sale, and there's two ways of selling your practice. You can either sell the assets, so take an inventory of the equipment and take an inventory of your patient charts and take an inventory of the goodwill of your practice and take that lease agreement and give it all to another doctor. And that's the sale of your assets. Now, alternatively, you could sell your charts and your charts alone. You could sell your charts to an existing practitioner across the street, or perhaps you're in a medical office building and there's another doctor in your building who's interested in buying your clinic, and they just want the charts. They don't really need your space because they have their own space. More than 80% of the doctors that I work with personally at Cirrus decide to sell both their equipment, their patient charts, and transfer the lease agreement. And the reason is very simple. That's how you maximize the sale of your business. If you were to sell your charts standalone, you're probably not going to net as much as a doctor who's selling their equipment, their patient charts, as well as the lease agreement. And if you are a tenant and you don't own the space you're in today, the lease agreement can comprise of as much as 100% of the value of your practice. And the reason for that is very simple. If you were to approach an associate, imagine there's a 34-year-old associate looking to buy your business, and you said to the associate, you can have my patient charts and my equipment, but you're going to have to relocate the practice, and you're located in San Francisco, and there's a shortage of locations because every corner is essentially occupied already by a dentist. There's a shortage of prime real estate for dental offices. What do? What does the associate do? Is there as much value associated with your business now that the buyer has to relocate the office? If you're in Indiana and you're in a rural part of Indiana and the buyer can, in fact, relocate the office and there is a space available, what's the cost of the relocation? Is it $150 a square foot? Are they going to be shut down for 4 months as they're relocating the office? And what liability does the associate have with regards to your current space if they're going to be buying your business? Can they relocate the business in time? So those are really the three key components that determine practice value. And again, any of these, and this chart is nowhere proportionate to what actually occurs at the time of practice sale, but it gives you a visualization of why the lease is so important. The equipment as well, it is important because the reality is if you're selling your practice, you want to have working equipment, right? If the buyer has to replace your equipment, they're going to factor that into the asking price. Now we're going to get into some of the common provisions found within the dental office lease, and this is where it gets very interesting. You have the opportunity right now to read what's called an assignment provision, and many doctors that have attended our webinars before typically will go to their lease agreement after the webinar, and they'll find an assignment clause that's not too dissimilar to the one that you see on your screen. Now this assignment or transfer provision, as it's commonly called, appears in a lot of lease agreements. In fact, it appears in more than 75% of dental office leases that we review. And I want you to take a minute or two and read this assignment provision. The assignment provision is the provision that affects your ability to be able to transfer the lease agreement to another dentist. So have a look at the assignment provision and think to yourself, if I was a dentist looking to maybe sell my practice and I had this sort of assignment language, what potential issues could come up when I decide to sell my office? So the first thing that you should have noticed is that in the event you want to transfer the lease agreement, you will need the landlord's consent. And the landlord doesn't necessarily have to give you the consent. The landlord can say, instead of agreeing to the transfer of the lease agreement, I hereby elect to exercise my option to terminate the lease outright. Or alternatively, I exercise my right to revise the minimum rent for the premises to be either a 15% increase or what is then the current market rate. And at that point in time, if another tenant has renewed their lease agreement within your shopping center or strip center or medical building, and they ended up paying a 14% increase, then your rental rate is going to go up by 14%. And that's how landlords catch you off guard. Many landlords insert language into the transfer or assignment provision in the lease agreement that allows them to not only not agree with the assignment of the lease, they get to dictate who their tenants are at the end of the day, but also to hold you liable, even if they're kind enough to allow the lease to be transferred and for another doctor to take over the space. as part of your transition, they will hold you liable for anything that goes wrong afterwards. If the associate or whomever you sell your practice to doesn't pay the rent, guess what? The landlord can, based on this type of assignment provision, go back to the previous owner and essentially ask the previous owner to make them whole, to make the rental payments that have come due and are past their deadline. So from that perspective, assignment provisions are critical when you're negotiating a lease agreement and when you're looking to transition your practice. Another common one we're finding today to appear more and more in lease agreements is the relocation clause. And the relocation clause, it may seem self-explanatory. Essentially, the relocation provision is the provision in the lease agreement that allows the landlord to relocate you throughout your tenancy. It could happen once, it could happen twice. I've had one client who had it happen 3 times before they reached out to us. And essentially, this allows the landlord to move you to a different unit or different space within their property. And why would a landlord want to do this? Well, a couple of reasons. A landlord may want to relocate you because they're accommodating an incoming tenant. A landlord may decide to relocate you because they have a space that is a bit larger than the space you're occupying, and it's been sitting empty. And they would love nothing more than for you to take over that larger space and to pay them additional rent for a couple of hundred square feet more than what you're paying now. And believe me, within your lease agreement, unless the landlord has stated if they relocate you, they can't relocate you to a space that's bigger, they have the ability to relocate you. We've had doctors that have been relocated to the back of the building, facing the dumpsters, essentially, whereas they had street exposure and great signage. That no longer exists once they have a different unit, and that unit is nowhere as attractive or as suitable as the unit they had previously. So from that perspective, relocation clauses are not good. They are in more than 50% of office leases that we review. Very common today in shopping center lease agreements, where you have a retail type of setting, you have different types of retail tenants, and the landlord likes to optimize their tenant mix and wants to have the flexibility to be able to relocate you. The key with relocation clauses, if you have them in your lease agreement, is to try to remove them. If the landlord isn't willing or amenable to removing the relocation clause, what you want to buy from them is time. You want to get notification. The landlord shouldn't come to you and serve you with a 30-day or 60-day letter saying you are hereby being requested to move to a new space, and you're to make that move happen within a certain number of days. In fact, I reviewed a lease agreement for a client recently where the relocation clause stipulated that the relocation would occur over a weekend as to not to disturb other tenants. Can you believe that? Imagine relocating your dental office and getting the right to do so from Saturday to Sunday. Is that possible? For most of my clients, at least the ones I've dealt with who are all dentists, and a combination of medical doctors and veterinarians, the only individuals in that group that can possibly relocate their office within a weekend are medical doctors with very little leasehold improvements. But even then, it's quite challenging to make that occur. Another provision which is common in lease agreements is options to renew. Why are options to renew critical when you're selling your practice? Well, if your lease agreement expires in 2017, 2018, anytime in the next couple of years, if you have a remaining term that's less than 7 years, when the buyer goes to the bank to finance the purchase of your dental office, and the bank finds out that your lease agreement expires in the next few years, the question they're going to ask the buyer, the associate or client, is whether or not there's an option to renew. And why are they asking their question? Do they care whether or not the doctor can actually renew their lease per se? Yeah, I think they do, because they're taking out a loan, and every bank wants to make sure that they get paid back the loan. So from their perspective, what they're looking for is term to allow the doctor to repay the loan. Very simple. Now, when you have a lease agreement that expires in the next few years and the buyer is savvy, what is the buyer going to do? The buyer is going to approach you and say, you don't have an option to renew the lease. Therefore, I am taking a risk of buying your practice with little security. If your lease expires in 2019 with no options to renew, what is there to guarantee that the landlord will be amenable to renewing the lease? So an option to renew is a provision that allows you to extend your tenancy. The way most options to renew are written, they're personal to the original tenant. We had a client a couple of years ago. In fact, one of my first clients was an associate who contacted me one day out of the blue and essentially explained to me that he had bought a practice approximately 2 years ago, and when he had approached the landlord with regards to renewing his lease agreement after buying the practice, the landlord said, "What option to renew? You don't have an option to renew." So he was surprised because he thought when he bought the practice he had an option to renew. Surely he opens up his lease agreement. There is an option to renew. In fact, there are 2 options to renew for a period of 5 years each. And then he contacted me basically asking me whether or not he had the right to extend the term, and because the landlord was explaining to him that he didn't have that right. So we reviewed his lease agreement, and we found out that when he had bought the practice, through our analysis of the lease, the option that existed, the 2 options for 5 years, didn't transfer along with the remaining term. And so he'd lost the option to renew. Had his lawyer, at the time of practice purchase, written into the assignment agreement that any remaining options to renew would be transferable and gotten the landlord to sign off on it, the young associate wouldn't have been in this trouble. So we had to go back to the landlord on the doctor's behalf, and his rental rate didn't go up because the landlord had essentially strategically put a renewal proposal in front of him, knowing that he just bought the practice 2 years ago and could not afford to spend $480,000 moving the office in a very competitive dental market. There are other provisions in your dental office lease. I do wish that we had a couple of days to run these programs, but most of you are very tired after working a long day, so we're not going to spend as much time on each of these provisions. I will spend a little bit of time talking about one provision that I find a lot of doctors are concerned about, and that's the demolition clause in their lease. A demolition clause is a provision that allows the landlord to terminate your lease agreement in the event they wish to demolish the property or have the intent to demolish the property. And if you have a demolition clause in your lease agreement, it may definitely inhibit sale and saleability of your practice, and the key there, just like the relocation provision, is to buy time. When can the landlord exercise the demolition clause? How much notification do they need to provide to you in order to allow you to move out of the property? Are they going to pay you for the undepreciated value of your leasehold improvements? So what are the stipulations surrounding that? Another provision that we find to be problematic with regards to assignment is the notion of financial statements. Now, financial statements can appear throughout the lease. Where it does often appear is in the assignment section, where it says, upon assignment or request for assignment, the landlord shall be provided with financial statements pertaining to both the assignor, the tenant selling the practice, as well as the assignee, the presumed buyer of the clinic. And if you're submitting financial statements, what are you submitting? Are you submitting production numbers? The landlord can ask for this. Are you submitting information regarding the value of how much you're selling your practice for? And if I told you that the landlord in every case owns the leasehold improvements, and in the appraisal of your practice it was determined that the value of your leasehold improvements was $300,000, then is that something that belongs to the landlord if the buyer signs a check? The landlord wants to request this information because they're trying to figure out what piece of the pie belongs to them. How do doctors fall into the trap of signing a lease agreement that is not properly set up for a practice sale? We generally find that most of you and your colleagues are working with a lawyer, and it depends on the type of lawyer you're working with. So some lawyers, for example, may help you with the drafting of the purchase and sale agreement, because you found a buyer, you've had the practice presumably appraised, and now you're ready to sell the practice. So your lawyer comes along, and your lawyer says, I will draft the purchase and sale agreement for you. Is that lawyer qualified to also negotiate the lease agreement or to analyze the lease agreement? unless they've negotiated hundreds of leases before and have actually been involved in transferring a lease from party A to party B, chances are they haven't come across the potential challenges that you may face when you try to sell your practice. The lease agreement is a very different type of contract than the purchase and sale agreement. And the lease agreement is a much more complicated contract because unlike a purchase and sale agreement, the lease agreement, in terms of its value, can increase liability by more than the actual sale price of the practice. And that's a risk to both not only you as the seller, but also to the buyer of the practice. And what you generally need is you need somebody who understands the rental rates in your market. You want to have an individual or a company who, or a firm who represents you and understands the legal liability side of the equation, such that before you sell your practice, ideally you have your lease agreement renegotiated. We had a 69-year-old doctor who recently came to us after realizing that his lease agreement wasn't properly set up to enable a transition. And the good thing is that he realized this before getting the practice appraised. Why? Because if an appraiser comes in and they evaluate your practice and they find issues with your lease agreement, they'll likely recommend that you have your lease negotiated and then reappraise the practice. And that's going to end up costing you twice as what it would have cost otherwise, meaning having the lease first negotiated, then having to have the practice appraised. You're not having to reappraise the practice twice in order to determine its value. I promised early on I was going to describe to you why it is that we only negotiate approximately half of the lease agreements that we review on an annual basis. And that has to do with the timing of the expiration date. And really what it comes down to is most landlords, when they're looking at their lease agreements as contracts between them and their tenants, they're looking at the expiry. Every lease has a commencement date and an expiration date. And what the landlord pays attention to is when the lease expires, because for them, that represents the ideal opportunity to renegotiate on their terms. You see, if I was your landlord and you had a lease agreement coming up for expiry in 2018, I wouldn't be approaching you this year. I may not even approach you next year. Where I may approach you is when you are very, very close to the expiry of your lease agreement. And the reason for that is because I will know the fact that it's going to cost you a lot of money to relocate the office. So if I come to you and I come to you, say, 3 weeks prior to the expiry of your lease term, and I say to you, Dr. Smith, your lease agreement and your rental rate is about to change. We're reflecting on your lease agreement the going rates in the area, and those going rates stipulate that we increase your rent by 8.5%. What options do you have at that point? You have the ability to say no to your landlord, at which point you'll likely lose your option to renew. You have the ability to relocate your practice. Probably not going to happen if you have 3 weeks of term left. So the landlord knows this, and the landlord tries to run out the shot clock. They try to approach you as close as possible to the expiry, unless they're planning on selling the building, in which event they may actually be very keen on having you sign a new 10-year lease term because that's going to increase the value of their property. So from that perspective, timing is everything, and not every lease agreement that we come across has an expiry within the next 2 years. And that's really the ideal time. 24 to 26 months, roughly, prior to the expiry of your lease term, assuming all else is the same, is the ideal time to negotiate a lease with a landlord. Now, that being said, if you're a doctor today who has less than 7 years of term remaining on your lease agreement and you're thinking about selling your practice, you need an individual or a firm who's going to work with you to be able to guide you through the assignment phase of your practice sale, the assignment of your lease agreement. And it doesn't matter when your lease expires. Do not undertake the journey of assigning your lease agreement without having somebody who can understand what is going on with the landlord and with the assignment process that the landlord is guiding you towards. And with regards to the notion of the lease agreement, there's really a 7-step process that we follow internally at Cirrus when we're negotiating a lease. And the first step is to gather all the documents. And what that entails is making sure that ideally we have an executed copy of the lease documents on file before we commence negotiations with the landlord. After we've obtained a copy of your lease documents, what we do, and you can follow the same process if you're thinking about negotiating a lease agreement, is we highlight all the risks within the lease, identify where are the key areas of concern, where do we want to focus on in order to maximize practice value. So if you want to go home tonight and basically take 3 highlighters and go to the assignment section of your lease agreement, identify the option to renew, you can do that. You can pinpoint exactly where in your lease agreement these provisions exist so that you're much more capable of being able to understand how they may either inhibit or allow you to sell your practice. After you've gone through and identified all the risks in your lease agreement, you want to do some market research. As a percentage of your production, is the rental rate reasonable or is it too high? Is it too low? Are you paying a rental rate that's way above market? And is the buyer going to notice that when you put up the for sale sign on your office? And that's something that you have to realize and pay attention to very closely. And after we've gone through the process of highlighting the risks in the lease agreement and doing the market research with regards to rental rates, only then do we start planning the negotiation process and thinking about what's important to us as tenants, and then we pick up the phone and we call the landlord and we negotiate the rent and the legal terms. And that process could take a couple of weeks, it could take a couple of months, and it could take 2 years. The process really needs to start, ideally, as soon as possible if you're thinking about selling your practice in order to be able to transition effectively. If you're planning on retiring in the next 2 to 3 years, it's critical that you start the process now. And if you have a lease that expires in 2 years for anybody, whether or not you're looking to sell, you should have the opportunity to negotiate it with the landlord, because when you decide to sell the practice, you may have a different landlord who's not as reasonable as the landlord you have today. And to summarize today's webinar, the details in your office lease agreement can end up costing you hundreds of thousands of dollars if left alone. It's not just about rent. Rent is important, but it's not the overall reason why, as a selling doctor, you should be concerned that your lease agreement may inhibit your saleability. If the rent is way too high, yes, the buyer may decide to not buy your practice, but there's a lot of other things in the lease agreement that may catch you and the purchaser off guard, including the notion of you being liable after an assignment, after a transfer, or then taking on the risk of having to restore your space to its original condition if they were ever to relocate their office. The lease is about minimizing risk, maximizing flexibility and practice value, and really achieving long-term peace of mind. And you want to be strategic. You want to ask for what you deserve. In negotiations, if you don't ask, you don't get. I have a lot of doctors that ask me, Sina, if we approach my landlord, am I going to rock the boat? Well, at the end of the day, does a landlord care more about getting a deal done and increasing the value of their property, or being very subtle about things and having an amicable friendship? The answer is they want both, ideally. But where most landlords draw the line is they'll take your check any day over that friendship. And from that perspective, having somebody who can facilitate the transaction and do it in an efficient manner goes a long way to buying respect from the landlord. Start the process early. You want to get ahead of your renewal or your transition, and you want to do your homework and research and ensure you have a plan in place that you can follow. Now, we covered a lot of content on today's webinar. For anybody who is overwhelmed, or perhaps you're not thinking about, I wonder what is in my lease agreement, I have some great news for you. We generally reach out to our industry partners to essentially solicit support when we put on these webinars, and we are able to offer a limited number of free consultations to doctors that have a lease agreement that want to take it a little bit further and have somebody read their lease for them. And this is something that we normally charge for, but for anybody who wants to have their lease reviewed, for the first 5 attendees that reach out to me, we'll book your lease review, and we'll get a copy of your lease documents and we'll review it. There are clients that are on this webinar today. Many of you have worked with us before, and I thank you for that. And for those of you that are perhaps on this webinar because you're thinking about, as we're going through this journey with you of negotiating your lease agreement, you're thinking about where the points are in the lease agreement that deliver value, I hope that I was able to convey that value to you again today. And for anybody who needs to speak with me, we'll take some questions right now. I'm going to use the chat window here on your screen to field some questions, and then we're going to take some polls as well, so you have the ability to find out what your colleagues are up to. And with that, I'd like to thank everybody for joining this presentation, and I'm going to take a couple of questions. So we're going to take a poll here. I'm curious to know what motivated everybody to join this webinar. And on the other end of the window, you'll see that we have an opportunity for you to type in your questions. And I do have somebody typing in their questions, so I'll wait patiently for that. All right, so two great questions. The first one is from one of our guest attendees who'd like me to talk more about new lease agreements for new dental practices. My comment to that is we are going to be, and we've hosted previously, some webinars specifically for doctors who are looking to start up a practice. So what I'm going to do is I'm going to defer discussing that topic on today's presentation because it is focused on selling your practice. If you're buying a practice and the landlord wants you to sign a new lease, it's critical that you have that lease agreement reviewed. But for those of you who are looking to start a practice from scratch, we will be hosting webinars on that particular topic to help you out. What type of language should be in the assignment transfer portion of the lease? So great question from one of the other attendees. What language should be in the assignment and transfer portion of the lease? It's a loaded question, but I'm going to try to address it as best as I can. You can put anything in the assignment provision. The question is whether or not the landlord will accept it and what's reasonable for the landlord to accept. So the first thing you want in your lease agreement under the assignment section is the notion that you have the ability to sign the lease agreement so long as you're assigning the lease agreement to a licensed dental professional and they've been able to secure financing to buy your business. Now, most of you have a lease agreement that says the landlord can determine or judge the creditworthiness, the net worth, the reputation, etc. of the buyer or the assignee. And that's very subjective because what's to determine sufficient net worth if you're selling your practice to an associate? Most associates have debt. They have a lot of debt. So the fact that they have a mortgage and $300,000 in student debt, is that going to give the landlord an excuse to not allow you to transfer the lease agreement? The answer is yes, because the landlord knows on the other end they have an ability now to renegotiate the terms, and they may allow you to sign the lease, but it may be conditional on a revised rental rate or you remaining as a guarantor for the balance of the remaining term. Another thing that you want in the lease with regards to transferability is the notion that if you do transfer the lease agreement, you're not going to be liable thereafter. And there's ways of, if the landlord insists on having you remain liable after the assignment, there's ways of limiting that liability to prevent your estate from essentially being at risk of having to pay rent for a space whereby the buyer of the practice decided to move out of and doesn't any longer respect the terms of their agreement with the landlord. And we have a couple of questions coming in on email. Those are private, so I'll address those. I'm going to put up the contact information slide here again, so that if you need to submit a private question to me, you can do so. My email address is on the screen before you. And again, I'd like to thank everybody for taking the time out of their busy day to attend today's webinar.